today's video, we're going to talk about some of the ridiculously big mistakes people make as executor of a will. So I'm Claire Langton-Yanowitz, attorney at the Yanowitz law firm, where we have been helping clients with probate for 29 years. When a loved one passes away, we are by your side. So here are some of the biggest mistakes that I see people make as personal representative or executor. So first of all, in Minnesota, we call someone appointed through a will to act and collect property on a deceased person's behalf. We call that person a personal representative. But in the United States at large, this person is usually called an executor. So the word personal representative and executor kind of mean the same thing. Okay, so just wanted to bring that up. Now, one of the biggest mistakes or major problems that I see is that a personal representative makes is that they may be really busy and they kind of delay doing the job. They may not be organized. They don't keep written records. And so those are all things that can create huge problems when you're taking on this role. So I think it's really important that before people decide to take on this role, that they come to terms with that it is quite a job, and that you need to have the bandwidth and time and desire to do all these things first off the bat. So it's really important when working with a law firm to, when we ask for things that our client will follow up promptly and find those things, or say that they don't understand what we're asking for so we can describe it better, or ask for guidance. So having that, prompt communication is really helpful in kind of getting the process moving along, reducing fees involved, having that good, clear communication back and forth with the client. So another issue that I see is sometimes, the personal representative, after spending, many hours, hundreds of hours working on this estate administration, they all of a sudden say, I want to be paid. I should be paid X amount. I've been working my tail off. I should be paid. And that it's better to, from the get-go, just start tracking your hours and what you're doing. You can do it on an Excel spreadsheet, mowed the lawn an hour, went to the bank, did these things, hour and a half. And because if you wish to be paid, it's important to kind of document all the things you did, how much time it took, so that later on you can prove this is why I should be paid X amount. So that kind of documenting can reduce a lot of conflict with the beneficiaries, and also can substantiate why you should be paid what you're being paid. Now, if you're not sure if you're going to be paid, you should just start tracking from the get-go anyway, because that way you can kind of track from the beginning and then decide in the future, I've spent 200 hours doing this, I want to get paid, or you know what, I don't think I'm going to get paid. Another mistake that I see that people make is that they want to get reimbursed for various expenses that, I had to fly to Minnesota because I was selling the home. I want to get reimbursed for that. It's important to save the receipt for your airplane ticket, to save the receipt for your hotel that you stayed in while you're in Minnesota, to save all that information, documenting proof why you should be reimbursed. So, and when you pay yourself out of the estate, when you pay yourself for a reimbursement versus paying yourself for doing the job of trustee, those are two different payments, okay? When you pay yourself for being the trustee, you're going to pay income taxes on that job, okay? It's a job, you're getting paid income for doing it, and so you're going to pay income taxes on it. when you get reimbursed for expenses, I mailed out all these things, and so now I'm asking reimbursement for the postage. That is not subject to income tax. That you paid something on behalf of the estate, and now you're asking to get reimbursed for it. So that's an important distinction that you should make. Now, another huge problem that I see that people do is they pay out the funds too early, okay? So there's this emphasis, I just want to be done. Let's, just settle up our bill, pay out all the money, and so we can be done with this. But if you are the personal representative, it's really important that you make sure that all the deceased person's final bills are taken care of before you distribute out all the money. Because if you distribute out all the money first, and there's later a liability that arises, you can be in trouble. You have to go back to the beneficiaries, ask for the money back, and they may not have the money. So that can turn into a big problem. Also, I wanted to mention that tax returns can be audited for up to 3 years after they're filed, if you don't file a prompt assessment. If you file a prompt assessment, you can shorten that down to 18 months, but it's 3 years otherwise. And so that means that you can file these tax returns, and the government can come back and say, no, the deceased person owes more in income taxes, and so you all of a sudden have to pony up and pay for that increased income tax liability. And if you distributed it out all the assets, you can be in trouble. Okay, so there's a couple of techniques around this that you can do. You can have beneficiaries sign repayment agreements that they agree to return the money if needed. You can do an initial distribution where you distribute out a chunk of the money, but you have a holdback for a period of time while you make sure no other liabilities arise. And then after a certain longer period of time, you can pay back that smaller holdback amount. So those are all sorts of things that you should consider instead of just paying out the money as soon as possible. You really want to make sure that you've dotted all your I's and crossed all your T's before all the money goes out of the estate, because otherwise, if there's something that arises up, it's going to be your problem. Another problem that I see is that sometimes a personal representative might not follow the terms of the will, and that's a problem, okay? This can happen a lot when mom and dad have loaned money or made gifts or whatever. There's some sort of agreement between the family that's not written in the will. And so, oh, well, so-and-so gets less because mom paid for whatever, and so now he's owed less. But the will doesn't say that. The will says he gets an equal third with his siblings, okay? And so that's a problem if people don't respect the terms of the will. There are some cases where if all the beneficiaries agree, you can enter into a non-judicial settlement agreement to transfer property differently than what the will says. It can be complicated. And what I find a lot is oftentimes someone thinks someone's share should be less, but that person might not think their share should be less. So sometimes not everybody agrees that is on the same table about that. So, and the final thing that's a huge mistake that has happened to me a couple of times is that we thought we collected all the assets, but we didn't. And then an asset is discovered later on, maybe a year, 2 years down the line. And when that happens, we have to reopen probate. We have to have a new court hearing to have someone reappointed. It's a big hassle, extra expense. So our preference is never to have to do that. And so it's really important that before you close probate, you do a deep dive search and make sure that you have collected all the assets of the person who died, that you don't leave any stone unturned. And so to help your family make sure that they collect all your assets, what's really important is to periodically write those those down so that your executor, your personal representative can find all your assets and they're not on some wild goose chase trying to track down what you owned here or there, that you write it down and you leave that valuable information to them in an organized format. So they're not, diving through bank boxes trying to figure out what you owned and didn't own. So thank you so much for your attention. And if you have any questions, feel free to send us an email or give us a call. Thank you.